The following discussion deals with legal options. It is emphasized that this discussion is not to be considered as legal advice, and it is not intended to create an attorney-client relationship. Please consult with an attorney who is a licensed member of the bar, as these documents can be complex, and based on your specific circumstances, they may be deemed legally ineffective. We now are ready to take up part 3 of our Aging Smarter podcast, The Prepared and Protective Elephant in the Room. I'm your host, retired former Circuit Judge Jose Rodriguez, and we're now diving into a topic that affects millions of people around the world, but we will focus on the loss of capacity that may flow from failing memory and from significant cognitive function as we age. It is our turn now to focus on what we can do prior to the loss of memory or capacity to make sure that our wishes are carried out regarding our medical, mental health, and management or disposition of our property and assets. Let's begin with a recap of the prior 2 parts. Part 1 of this Aging Smarter podcast we will call the longevity elephant in the room. We were able to statistically establish that we're living longer and that we need to take care of our bodies as we age with regular visits to our doctor. In part 2 of this Aging Smarter podcast, we dealt with dementia and mild cognitive loss due to aging. We will call part 2 the memory elephant in the room. Now, the research led us to a conclusion that genetics plays a role, but more universally, aging is the main risk factor to develop mild cognitive loss or dementia. So it's simple to say that none of us is born with or has attached to us a crystal ball to let us see what the future is going to bring. Equally, research has shown that there is no way to forecast who is going to keep and who is going to lose their cognitive function and abilities. The smartest elephants in the room plan for the time that their memory might fail and when their reasoning doesn't hold up. In some cases, the potential loss of memory and cognitive function may negatively affect one's ability to decide appropriate medical or mental health care and upkeep of properties or finances and maintenance. This is where the preparation of our legal toolbox is necessary to make sure that our wishes are followed and our health and property protected during the long race. Our preparedness and protective elephant in the room has hopefully awakened and has previously worked to put writing its wishes. As we discussed in more detail previously in episode or part 2 of this episode, the loss of memory and capacity as a result of aging or illness does not necessarily affect everybody in the same manner. Some are unable to manage their affairs. Some can suffer an all-encompassing and debilitating inability to care for themselves. Others may need some assistance, and others can carry on with the management of their daily affairs just like nothing had happened. What alternatives do we have, and what alternatives are appropriately? Part 3 of our Aging Smarter podcast is about prepared and protective. The prepared and protective elephant in the room. This elephant will dig into some of the available methods to prepare for the time in our life's journey, our race to the finish line, during which we live longer but may have lost some of our cognitive abilities. This discussion deals with legal options. However, this discussion is not to be considered legal advice, not intended to create an attorney-client relationship, not intended to substitute for the advice of an attorney. No podcast is a substitute for speaking directly to an attorney about your specific situation. Please consult with an attorney member, licensed member of the bar. So it's simple to say that none of us is born with that crystal ball that lets us see into the future. So how do we become that protective and prepared elephant in the room? Why does it matter? Well, it matters because you can avoid guardianship. Guardianship is, if we look at the big picture, deals with an adult becoming incapacitated and a legal decision being made because plans have not been made in advance where a court can appoint a guardian to make decisions for them. In other words, the court has appointed someone to make those decisions that you should have left instructions or wanted to leave instructions for someone to do your bidding, to do what you wanted to do, to spend your money or not to spend your money, to treat you and to make sure that your health care is provided for. The process of taking your rights away and delegating them to someone else is what guardianship is all about. Your civil rights, your rights to determine where you live, rights to determine what to do with your assets, your medical and mental health care, goes to someone else to make those decisions. In Florida, if an adult becomes incapacitated and hasn't made legal plans in advance, a court can appoint a guardian to make those decisions for them. This process, known as guardianship, is governed by Florida Chapter 744 of the statutes. Under the statute, if someone is believed to be incapacitated, a court will appoint an examining committee to evaluate the person's mental and physical capacity. Based on the findings of this committee, a recommendation is made to the judge. The judge, by clear and convincing evidence, would make a finding that would result in the assignment of someone else, those rights to someone else to take over the major life decisions, including your finances, your health care, even where you live, whether you can vote, whether you can't vote, whether you can marry. A whole host of civil rights will be can be delegated to someone else. Florida, however, is good in that it emphasizes that the judges must consider less restrictive alternatives before appointing a guardian. So, how do we plan ahead to avoid unnecessary guardianship? Because, quite frankly, a guardianship also costs a lot of money. Let's explore the tools that will help you stay in control, in other words, both legally and practically, of your life and of your choices. The toolkit for staying in control basically deals with legal documents and strategies that you can use to express your wishes and to designate trusted people to help carry them out. And let me warn you about those people that you might designate because you find and you feel that they are trustworthy. A court will go ahead and they may appoint them, but they also reserve the right to protect you by determining whether that individual that you have named is in your best interest. For example, if it's a family member that has used your funds to pay their mortgage, that is not a reliable person, according to some of the cases that have come out. Again, the court will have the final say whether the individual that you have named in any declaration, in any document, whether that individual is in your best interest. So again, someone that you want, someone that you trust, that is a beginning. So what do you do? Under Florida statutes 744.3045, 744.3045, you can legally name who you would want to serve as a guardian if guardianship becomes necessary. This is called a declaration of pre-need guardianship. You remain in control of your choice until such time as the court decides that it's not in your best interest. But the court, again, has to give priority to the person that you've selected, again, unless they're found to be unqualified and that person is not in your best interest to serve as a guardian. It's a simple form, and all it has to be is signed and witnessed. And it can save your family a great deal of conflict, and it can provide for certainty. Uncertainty is done away with as to what your wishes were and who it was that you wanted to take care of your belongings and of your health care. Next is a designation of healthcare surrogate and a living will. Chapter 765 of the Florida statutes govern both the surrogate designation and the living will. I have an issue with the term living will because it may tend to confuse someone with a last will and testament. Well, a living will obviously is not the last will and testament, but what it does do is it lets you speak for yourself. It basically tells someone, your surrogate, with whom hopefully you have spoken, about what your wishes are regarding your end of life care. Whether you want to be kept alive, whether you want to be intubated, whether you want to be maintained on all kinds of feeding tubes, whether you want to be kept alive artificially when there is no hope of recovery. I think some of the terms that are used is whether you're in a persistent vegetative state. These documents give guidance and legal authority to your surrogate to make the decisions you want for yourself. Without them, your loved ones, well, they are going to struggle to make decisions. Or you may have siblings that disagree. You may have family members that, well, will never talk to one another because you chose some alternative that they wouldn't have chosen. When your wishes are expressed, that feeling, that bad feeling amongst family members should be minimized. Notice I said should be minimized. There's never a guarantee on that. And finally, there's another document that you can sign if you want life to be extended beyond you by organ donation. Florida Statute 765.512 gives you the right to execute a document that provides for your wishes to be an organ donor via your driver's license or via your healthcare documents or a signed donor card. It's a powerful, powerful way to leave a legacy of life and a document that consents and clearly prevents any confusion at any time about what your wishes were. Fourth, it's a DNRO, a do not resuscitate order. This was a bit different. A do not resuscitate order is not a living will. It's a formal medical order that states that you do not want CPR or advanced cardiac life support if your heart stopped. In Florida, a DNRO must be executed on a yellow paper, they call it canary yellow, using Form 1896 as required by the Florida Department of Elder Affairs and the Department of Health. It must be signed by both the patient and the physician. It must be easily accessible. When you can leave it in your fridge, you can put it in your chart at the hospital, or file it with the emergency folks that may give you the ride to the hospital. Well, let me tell you an interesting story about something that happened back in 2017. The Washington Post reported a story about a 70-year-old man in Florida who was brought unconscious into an emergency room. Now, this means that you need to remember what the requirements are, right? On a yellow piece of paper, signed by the doctor, signed by the patient, and again, on file. On yellow paper, canary yellow to be specific. Well, this man comes in. He has no ability to communicate. Remember, what we're trying to do is avoid the non-communicating individual, but that non-communicating individual still having a voice in a document that's left behind. Well, in this case, the man had a DNR, a do not resuscitate tattoo, and it had something that looked like a signature. So what happens? My gosh, it's not on the form that's prescribed by the Department of Elder Affairs or by the the Florida Department of Health. So he comes in, and what happens? The folks in the emergency room are kind of spooked because they don't know what to do, and they don't know whether to honor the tattoo that doesn't meet the legal requirements of Florida law. Well, they called an ethics consult. Kind of like ER, the television series. You call for an ethics consult. You go for a psychiatric consult. But in this case, the ethics consult started thinking about, why do we have DNRs? And DNRs are there for the specific purpose, as we've been talking about the prepared and protective elephant, so that your wishes are carried out. You think a tattoo doesn't tell what someone's wishes are? Well, guess what? The doctors reasoned after an ethics consult that they would honor the tattoo Okay? They honored the tattoo because it appeared to be one, a good quality tattoo. Don't ask me what that is, but I guess they were the judge of that. The doctors were the judge of that it was a quality tattoo. It seemed that it was done to express his intent, which is what a DNR is all about. And that it was an intent to receive a life sustaining, that he did not want to receive any additional life sustaining therapies. So, I mean, it even had a signature or something that looked like a signature. Well, guess what? Several hours later, the hospital staff was able to identify the man, find where he lived in an assisted living facility, and found that, in fact, he had a DNR that was on yellow paper that met all of the requirements. But you know what? They came to the right conclusion that, again, it was all about the intent, the communicated intent of that individual. All right. What else do we talk about? We've talked about health. Now let's talk about money. What? Money? Yes, money. Why? Because it's important. It's one of those elephant issues, the elephant money in the room. So, first of all, you need to figure out who you trust with your money. And then what you may want to do, again, is contact your lawyer so that before you have to go through guardianship processes, that you can have a power of attorney. Power of attorney can substitute for a guardianship, particularly a durable power of attorney, because a durable power of attorney survives you being found incapacitated. That means that the person that you entrust your financial affairs, your property, and everything else, a durable power attorney is the kind of document that requires certain things. It requires a particular language in order to survive the determination of incapacity. So, moving on, if you're incapacitated, whoever you name as your agent in the power of attorney will wind up having say over your belongings, over your property, and over, again, whatever you have agreed in that um, document that the individual has the power to do. If it does not have the specific durable power language, it will not survive incapacity. That's why it's important that a lawyer look it over to make sure that the statutory language that includes the durable portion of it, the portion that survives incapacity, is included. Again, power of attorney is extremely complicated. It is so complicated that in Florida, there are requirements for additional initialing of certain portions of the document that I guess is statutorily supposed to, I really, really mean it. I really, really meant it. So I've got to go ahead and initial it because it's a real complex section of my power of attorney. So again, but a power of attorney not only requires signature, it requires witnessing, and it should be signed by two witnesses as well as notarized. The important thing about signatures, about all witnesses, is that the witnesses should be as free from conflicts as possible. What do I mean by that? While, except with the healthcare designate or the healthcare surrogate, you should endeavor, okay, the healthcare surrogate requires that someone other than family members, that at least one of the witnesses not be a family member. But the best policy is to have people who are not either um, by blood or by marriage tied to the individual. In other words, that there's no relative involved in the witnessing. That way, you've got somebody that may very well be seen by the courts as not interested in, not in conflict. So again, uh, A power of attorney needs to be witnessed and needs to be notarized. Um, Otherwise, it may be found to be ineffective. The best policy, because powers of attorney are so complex, is to have it reviewed by an attorney. Now, when talking about your financial decisions, durable powers of attorney are some of the most powerful instruments that you can draft. Let's talk about money. First of all, you need to find out somebody you really, really trust to trust with your assets, with your finances, with your wealth. Under Chapter 709 of the Florida statutes, you can create a durable power of attorney. That legal document gives someone the authority to manage your affairs if you become incapacitated. Durable powers of attorney require specific language, and certain specific statutory languages will be required in order for that power of attorney to survive in the event that you are found to be incapacitated. Now, if the prescribed language under the statute is not included, then the document will not survive your incapacity. Now, again, durable powers of attorney can be complex. Because they are complex, they can require attention and the advice of an attorney. There are conditions that you can include in your durable power of attorney that are so complex that the statutes require additional initialing of those sections. Here's some things to consider. A Florida power of attorney, durable power of attorney, is effective immediately upon signing. You can revoke it at any time. It must be signed by 2 witnesses and notarized. One witness must not be a family member if it's a medical power of attorney or a healthcare designation, which probably would include a healthcare surrogate. You, as principal, can limit or expand the powers of the agent. Durable powers of attorney are incredibly powerful. But if you do not include expanded powers of your agent, the finding of guardianship can lead to the suspension or the deleting of your durable power of attorney. So, to be as expansive as possible is one of the requisites to avoid guardianship as well. Again, if there is a move to establish a guardianship and there's a durable power of attorney that exists, the court is going to find out whether or not to go with the guardianship and find someone incapacitated or let the durable power of attorney exist in its stead. A durable power is a less restrictive alternative to guardianship. Unlike guardianship, a durable power of attorney does not require the finding of incapacity and the removal of a person's rights. Another way to avoid guardianship is by executing supported decision making agreements. This option is getting more attention since it became law in 2024. This is especially useful amongst younger adults with disabilities. It can also be used by older adults. These documents are called supported decision making agreements because they're a formal way to get help making decisions without giving up your legal rights. Florida now recognizes supported decision making agreements as less restrictive alternatives to guardianship, especially when they are combined with the power of attorney or healthcare surrogates. They're extremely powerful ways of avoiding guardianship. Why? You choose your supporters, you retain all decision making rights. Supporters help you understand and communicate your decisions. They do not make them for you. Chapter 709 of the Florida statute specifically states that assisted decision making agreements are not powers of attorney and do not have the same binding effect. Supported decision making agreements allow supporters only to make and communicate decisions, but those same supporters do not have the power themselves to make binding decisions. Theirs is a role of decision making assistance and communication. These decision making supporters generally will help an individual understand information, weigh their options, and help communicate those decisions to others. This model is grounded in self determination, and it can help preserve independence while still offering a support system. Let me give you an example of how these supported decision making concept works. Not every one of us has the expertise to make complex financial decisions, and we will certainly turn to a doctor for medical advice. So, in matters of money, we search for financial advisors or investment counselors. For matters of health, we turn to doctors. In the same manner, individuals who may lack the ability to make some decisions will choose who they will rely upon to assist and support them to make everyday decisions, such as paying bills, making health decisions, and communicating them to others. That is what supported decision making is all about. We have them. Those who need assistance may refer them to their supporters. Some final thoughts here. And you know what? This is all about taking control before the crisis hits. Guardianship is avoidable, but only if you plan ahead. Florida law provides powerful tools like pre-need guardian declarations, living wills, healthcare designations, including the naming of healthcare surrogates, the durable powers of attorney, DNROs, do not resuscitate orders, organ donations. All of these keep you in the driver's seat. You don't have to wait until something bad happens. In fact, you shouldn't. Smart elephants in the room have been listening and will not forget to take action. Take the time now to talk with an attorney who has experience in the elder law or estate planning area. Get your documents in place, and most importantly, talk to your loved ones about your values and their wishes. It's just like the elephant in the room. Planning should not be ignored. And please remember that the preceding discussion dealt with legal options. It is emphasized that this discussion is not to be considered as legal advice, and it is not intended to create an attorney-client relationship. Please consult with an attorney who is a licensed member of the bar, and these documents can be complex and based on your specific circumstances may be deemed legally ineffective. The discussions of these documents and these issues will hopefully refine and sharpen your questions to your attorney regarding what to do to become a prepared and protective elephant in the room. Again, remember, this podcast is not intended to provide legal advice, create a legal attorney-client relationship. So I'd like to, at this point, many thanks to our showrunner, Art Miles, a man of many talents and a warehouse of knowledge and talent, our AI producer of Part 3, Mike Nichols, our executive producer and logo master designer, Annie Newbern. Again, please remember, like and subscribe. Don't forget, every good elephant remembers every good elephant plans to protect themselves and those around them. Till the next time.